Here are a few things you should know about changing your support order by agreement without going through court. Hi, I'm Alycia Kinchloe, the owner of Kinchloe Law, a family law practice based in the Philadelphia area. Now, when you have a support order, you are ordered to pay a certain amount on a regular basis. Now, that can be done either through wage attachment, which means it comes directly out of your paycheck, or it can be required that you pay it directly to the other person or that you pay it to the court. Often that happens when the party who's paying the support is self-employed or has some other type of irregular employment, like perhaps they're gig economy workers, so maybe through Uber or some other way where it cannot be directly taken from their employer. So in that type of situation, you are responsible for making your payments directly to the court and making sure that they're done in the correct amount and done timely. Now, at times, parties may agree to change the amount of support. Now, as always, we want to remind you that you should speak with an attorney licensed in your state about the facts specific to your case, and that this video, like our others, are not legal advice, but are for informational purposes only. So at times you get people needing to or wanting to change the amount of the support obligation. Now, when that support amount or that agreement amount is below the obligation for support that is court ordered, and even if it's a court order by agreement, if it's an agreement that has been entered into the court, you want to make sure that you understand the potential repercussions for not paying the full amount where the court is on notice of what you should pay. So, for example, let's say that one of the parties or the person paying falls on hard times and they reach out to the other person who's receiving the support and say, can I pay you half the amount or can I make half the payment? Again, this is in situations where the support is not wage attached. But can I pay you a part of the amount until X date or for a period of time? Now, if that person says yes, they may accept the lower payments. The issue you may run into is that if you are going through the court and the court requires you to pay the payments directly to the court may not be aware of this arrangement. And if you don't file an agreement or a modification, the court can still think that you are falling into arrears. And what can happen is that it can trigger enforcement. In some counties, it takes as little as 3 missed payments for enforcement to be triggered. And enforcement can be done as a number of ways. It can lead to your bank account being frozen. It could lead to tax returns being garnished. It can also lead to a bench warrant. So you want to make sure that you understand that if you do agree to change the amount of support, either lower and even sometimes higher, but if you agree to change it lower, you want to make sure you go through the court or that you have your temporary agreement somehow filed with the court so that they know that you're not falling into arrears. And those things that are triggered enforcement, which may not be done by the other party filing, but can be done sua sponte, so by the court itself, because you fall into arrears. Now, in a situation where you are paying more than the support agreement, you really don't have a potential issue. You want to keep track of this if for some reason you need proof that you pay a higher amount, but you do want to make sure that you understand that a higher amount or giving more money typically doesn't hurt you. It's the issue of where you're paying less than that potentially raises an issue. So if you are going to go for a lower amount or agree to pay a lower amount and your order is through the court and you're supposed to pay it through the court, you want to make sure that you have that agreement. Now, if the agreement is that you pay the amount directly to the other party and they are accepting a lower amount, you want to make sure you get that in writing and get it signed. So situations like this may be where there is a marital settlement agreement. You want to make sure that you read the agreement and understand what situations allow you to change or alter the terms of the agreement and which way that may be done. So again, what you want to do is if you are the person paying the support, you want to make sure that you're protecting yourself. Now, when it comes to someone filing contempt, you may have a number of arguments to make and say, look, this person agreed to take it. But they can come back and say, no, I didn't agree to take it, or I took what you could give me, but that doesn't mean that I didn't want the rest of it. So you want to make sure that you're protecting yourself, because as the obligor or the person responsible for paying the support, you have a responsibility to pay the amount that you're ordered to pay, either by court order or by agreement. And if you fail to do so, you are the one who can face the consequences. All right, and I hope to shed a little bit of light on what could happen if you choose to pay an amount different than, especially less than, the court-ordered agreement or court-ordered support obligation that you are required to pay. If you have any questions about this, you can reach out to our office by visiting KinchloeLaw.com, or you can make sure you leave a comment below and ask us questions that you would like us to cover in future videos. Remember, we're doing this every day of 2021, and we're covering issues related to divorce, custody, and support. Until next time, take care.